And again, the question comes back resoundingly, and it varies again between the high 80s, 87, 88% and 97%, depending on the particular right and the particular moment and what's concerning people at that time, vital or important in relation to each of the component rights and freedoms in the Convention and now in the Human Rights Act. And then the third and final question that we ask repeatedly in this poll. Do you remember ever receiving any public education from the government about the Human Rights Act? And 9% of those polled say they did. And they are delusional, because I never got my leaflet. Because it never came. So that's a false memory. I must have done, mustn't I? I must have done. Never happened. So on the one hand, this strange contradiction of those new Labour years in Britain, some good things, some great things, like the Human Rights Act, like great progress towards gay equality, which was often linked to, as you know, convention litigation in Strasbourg, and then subsequently work under the Human Rights Act. Great progress on those fronts, but of course the other side of that of the equation was dishonouring those human rights principles in other areas of policy, in thought, in word, and in deed. And of course it was, so you had a government that was ambivalent about its own child, its own Human Rights Act. You had the terrible twist of fate that 9/11 came less than a year after the implementation of the Human Rights Act. So the infant instrument barely toppling to its feet when 9/11 happened, and therefore those early years of the Human Rights Act, of that infant Bill of Rights, surrounded by the narrative of the war on terror. Other problems, the decimation of legal aid began then. We've had no public education. Instead, the narrative about human rights in Northern Britain has been a narrative about litigation as mediated by the press. And of course, the litigation that we're talking about, legal aid having been in decline, is going to be on the one hand celebrities and their privacy interests, and on the other hand refugees and terror suspects, who might as well be in the same category, by the way. Right? That is the public information, that was the public education about human rights in those difficult years of the war on terror. So hardly surprising that there is some controversy about the Act. And returning to the media for a moment, and don't get me wrong, as a campaigner, the media is vital. No desire to censor the free media or the raucous press, all these other glowing terms that we used to describe, and newspapers in particular in Britain. But it has to be said that the media is not neutral when it comes to the Convention and to the Human Rights Act. And some senior editors in particular have been very blunt about the concern that Article 8 has impeded the ability to kiss and tell. They've been very, very clear about that, and that has fueled some hostility towards the Convention. Some of these same editors and newspapers will be very, very critical, rightly so in my view, of intrusions by the Big Brother state, whether it was the attempted introduction of identity cards or CCTV, Britain, etc., etc., etc. Don't like the Big Brother state, but they like Big Brother Murdoch. Potential tension and contradiction there for human rights people, I would suggest. You have to look at abuse of power wherever it comes from state or non-state actors, as I know you know very well. Nonetheless, in that difficult climate and through those difficult years of the last decade, the Convention and the Human Rights Act have given real protection in all sorts of incredible really valuable players. Your conference is about political commitment on the one hand and practical protection on the other, or the Human Rights Act has had a lot more by way of practical protection than it has by way of political support. Section 2 of the Human Rights Act requires our judges to take account of Strasbourg jurisprudence, a wonderful device, I would argue, that allows the proper level of discourse between a domestic and an international judiciary. Now, at times, it could be argued, it has been argued by some of our judges themselves, that injunction has been ignored or not followed enough, and that Strasbourg jurisprudence has been treated as binding precedent. I don't think that should happen. I don't think that an international court should be treated as a final Supreme Court. And I think the whole point, or one of the major points about the Human Rights Act, is that a domestic judiciary should be able to contribute to developing international jurisprudence about human rights. And I think that is something that is being more accepted now by the senior judiciary, not least in the context of this very, very troubling political atmosphere that seeks to challenge Britain's membership of the Council of Europe, let alone the survival of the Human Rights Act. Section 4, this device of the Declaration of Incompatibility. I know it's too soft and namby-pamby for some human rights folk, but it has, as in the Belmarsh case, allowed a very effective discourse between the two important limbs of our Constitution, if we can call it that, our imaginary or slightly elusive Constitution, if you like. It's allowed proper discourse between the judiciary and Parliament, sometimes an executive-dominated Parliament. And the Belmarsh case was a great example of the powerful moral and persuasive effect of declarations of incompatibility whilst people still care about human rights. And Section 19 of the Human Rights Act, which requires ministers introducing yet more legislation. They do like to legislate in London, I have to tell you. Talk is cheap, legislation is almost as cheap. Section 19 requires ministers introducing all of these so many bills to make a statement about their belief of the compatibility of the legislation. And even for my own time working in government, one could see the discipline that this began to impose on government lawyers and officials who were drafting legislation for ministers and on the policy-making process, let alone on the parliamentary process. And I think that process has also been enhanced by the establishment of a joint parliamentary committee on human rights. And of course, Section 6 of the Human Rights Act is really the meat in the sandwich for many people. This is the requirement on public authorities, including courts, interestingly, to act compatibly with the Convention. And of course, it's the including courts bit that is affected the common law. So the courts themselves, when developing common law, when interpreting it, should do so compatibly with human rights. And through those enforcement mechanisms, we've been able in many cases to give life to the Convention back home.